All right. Well, welcome back. I hope that you guys all had a nice little break. We are now officially into the afternoon portion of our first day, and we're going to be looking at Cannabis 2021 and beyond, navigating the current and evolving federal and state regulatory landscape for CBD, cannabis, and cannabis-derived products. Moderating the session, we have Tom Zuber, from the managing partner at Zuber Lawler. Welcome, Tom.
Thank you, Ashley. It's a great pleasure to be here. Hello, everyone. Thank you for joining us. Today, we're here to talk about navigating the current and evolving federal and state regulatory landscape for CBD, cannabis, and cannabis-derived products. And we have a great panel and a good variety of perspectives here. I'm going to go ahead and introduce my panelists. First, we have Dinh, Associate General Counsel at the USDA. Hello, Mai. Welcome. And can you tell us a bit about yourself and what you do at the USDA?
Sure. Hi, Tom, and thank you for this opportunity to speak at this conference. I am the attorney who oversees the legal staff that supports the Agricultural Marketing Service and all the programs under that agency. And so that includes the Hemp program. I was involved in the agency's drafting and implementation of the new regulations.
Thank you, Mai. That's a great perspective. And next we have Kathryn Farrara. She is Associate General Counsel at UNILEVER, North America. Kathryn, hello, welcome. And can you tell us a bit about yourself and what you do at UNILEVER?
Hi, Tom. I run an incredible team of lawyers and paralegals across North America with a pretty broad scope. Starting with like deep innovation several years out, all the way through to bringing that project to life in the marketplace. And of course, managing the intellectual property and the quality and the regulatory issues that can come along the way. So I really enjoy the work. We get to work hands-on with the marketers, and that gives us a chance to really use our expertise to get creative. Which is one of the parts of the job I really love.
Wonderful, Kathryn. And it's great to have your perspective here on the panel. Thank you. And Chris Davis, who I've known for some time. Chris, can you tell us about yourself as Executive Director at the International Cannabis Bar Association and the great work you do there?
Thank you, Tom. I'm happy to. My name is Chris Davis, as Tom mentioned. Tom is one of our members. He's one of about 800 attorneys here in the United States and abroad that are part of our association. So we were founded in 2015 as the National Cannabis Bar Association. We were founded to help attorneys figure out how to best serve their clients in this industry. And so we were founded before the regulatory implementation here in California. In anticipation of that, of course, there was some gray area that lawyers were forced to operate in. Our group sort of helped teach each other what was going on in that sort of gray area. And then as regulations have been implemented across the United States, as federal policy has started to kind of come into the limelight, we have helped our members navigate those issues, everything from ethics, so sort of the attorney's own self-regulatory, internal-looking regulatory compliance, all the way down the line through intellectual property, finance, securities, obviously everything that you do in your firm. We've enjoyed having you guys as members, and so really excited to have this talk today, Tom.
Thanks, Chris. Thanks for joining. And so what we're here to discuss is, the evolving federal landscape and state regulatory landscape relating to CBD, cannabis, and cannabis-derived products. One of the things to note at the top of this conversation, for those who don't know, is that there's a great deal of disparity at the various levels of regulation. So you have the municipal level, and there's the state level, and then you have the federal level. And of course, cannabis, THC-containing cannabis, to be clear, it continues to be prohibited at the federal level, but increasingly, we've seen states legalize, and municipalities underneath states legalize THC for commerce within their borders. On the other hand, the 2018 Farm Bill removed hemp, cannabis containing less than 0.3% THC, to be specific, from the definition of marijuana, so that commerce is opened up in relation to hemp as opposed to THC-containing products here in the United States. So on that note, Maya, I think it's appropriate to start with you. You certainly speak, I think, on behalf of the federal government in some regards, some very relevant regards. So can you provide us some insight as to the status of federal regulation relating to cannabis, especially, of course, cannabis and foods, including as to the interactions between various federal agencies and how that works?
Sure. So the 2018 Farm Bill came about, vested into USDA the responsibility for regulating hemp. And so the agency decided to go to Agricultural Marketing Service, and they very quickly put out what's called the Interim final rule just to get the program started to regulate hemp. And the way that the Farm Bill worked was that hemp, if it had a THC level of 0.3 or less, was no longer a controlled substance. It also said that the THC that's found in hemp is not controlled. And so USDA brought out new regulations about how you cultivate that, how it's being measured, how it's being tested. It also set up, per the statute, a partnership between the federal government and state and tribal governments and how to co-regulate this in states. So it gives states and tribes the opportunity to decide whether or not you want to regulate hemp. And if they do, then they have their own program that's subject to USDA approval, but they have primary responsibility for the regulation of the production of hemp with USDA oversight. I'm not going to get into all the details of what the statute, the regulation says. I can talk about that for hours. Just a few key things that I think take away from that. The first one is that there is a preemption in there. There's a non-preemption, excuse me, in that what the federal statute is this is the floor. This is the federal standards. Every state wants to be more strict than that, than what is in the federal standards, they can. And what that means, though, is that even though we may put a 0.3% THC level for definition of hemp at the federal level, if a state wants to go with a different number that's lower than that, they're certainly free to do so. I haven't seen any state to do that or tried to do that, but that's a possibility. The other thing that the Farm Bill did was, in the area of preemption, was said that if the hemp is legally produced under the program, whether it's under the state program, the federal program, or the tribal program, a state cannot prevent the transportation of that product through its borders. It can prevent it from entering the borders if they have a law that prevents it, but they cannot stop the transportation of it through their borders. And it was a key thing to allow for the balancing of state interests and being able to regulate it or prohibit it if they want, though I don't think of any states today that is prohibiting hemp. But it also allowed them to do that, but it didn't allow them to stop the commerce of that. And the other thing about hemp that USDA did was it said the regulations only covered up until harvest. So USDA regulation of hemp today only encompasses the production of hemp until it is harvest. And into that particular thing is obviously hemp as a product continues on, has a life cycle. And so there's a couple of things that the Farm Bill did. It preserved within FDA the authorities to regulate hemp products under the Federal Food, Drug, and Cosmetic Act. And it also left within the understanding that it's a state, tribal, federal area. And so what we have here is the FDA still retains authority under its FFDTA to regulate products that have hemp in it and its derivatives, which is a CBD. And what FDA had said was that because CBD is an ingredient in a drug that was approved before hemp was legalized. It's in a epileptic drug that's used for children. It is now a controlled drug so that it cannot go into food unless FDA exempts it. So it goes through a process that allows it to be entered into food. FDA has not done that process. So technically, as of today, CBD should not be allowed in food until FDA gives the clearance to do so. The other thing that FDA also has jurisdiction over is, and also FTC, frankly, is false claims. And so they have sent a number of warning letters to various companies that make claims that CBD has a health benefit. And so and those letters should be taken seriously. And there's a joint effort between FDA and FTC. The other thing that happened with the Farm Bill was that when it removed hemp and THC in hemp from the controlled substance, DEA went out with a regulation, an interim final rule that did that for their regulations. Within that regulation, they also did say that if through the processing, it does, the hemp or the hemp product exceeds a 0.3 threshold, then it could be considered marijuana and controlled. I'm not going to get into that too much because that aspect of the rule has been challenged in court. And currently, I believe that the case in the district court got dismissed because of venue issues and is now before the DC Circuit. The plaintiffs in the case have filed their briefs, and I think the government's brief is due at the end of this month. And so that's where we are in the federal space. USDA is here up into harvest. FDA has gotten into a little bit about what happens at processing, and FDA has the finished product.
Pardon me. Much more eloquent when my mute is on. So you're welcome. I have a question for you, and it's not necessarily a fair question, but since you are working with the federal government, I'm going to ask, what's your notion, even if it's speculation, as to whether or not the federal government will do something relating to THC prohibition anytime in the near future?
Well, it depends on the THC, right? Mm-hmm. THC in hemp is not controlled.
Right.
And so that was a function of the 2018 Farm Bill. The question, I'm hesitating simply because it's litigation over this, and it's not party to the litigation. And so I would say that that's something that we in the federal government among the agencies certainly talk about, and that and things that we yet to see how the litigation plays out and have that conversation among the agencies in the federal government that have an interest in equity in this space.
Thank you, Maya. I appreciate that. I promised our hosts, everyone, that I would read a CLE code for those of you who are watching this for CLE purposes. And that code is G as in Gary, U as in U-boat, 1256. G as in Gary, U as in U-boat, 1256. Kathryn, let's go to you next. I'd like to find out from your perspective at UNILEVER, can you talk about some of the unexpected difficulties of getting hemp-containing foods onto shelves here in the U.S., including from a labeling standpoint?
So we haven't done it in foods. We have done it in cosmetics. And to be honest, I think really it is half the battle is trying to clarify with the business what a hemp seed oil is actually going to do in your product. Right? Because there's confusion about, just how you bring this concept to life, and kind of like blurring the lines into things that are more CBD or THC attributes. And so half of the battle is kind of just getting everybody on the same page. Right. And then, I think for us, when we first kind of dove into hemp seed oil, we knew that we had several brands that were interested in doing it. And we realized that the biggest hurdle was going to be making sure that we had, a well-controlled, really established quality assurance program on this. We were very concerned at the time about sourcing, ensuring, coming up with a method, validating that method so that we knew that we could actually demonstrate that we were below those levels and that we were receiving the right kind of product in the first place. And I think that was really helpful because that was a huge unlock in terms of, multiple brands and being able to get to the marketplace. Little things like even finding a lab that could validate the method for us is not that easy. So it's a lot of these more, these steps that the marketers aren't always privy to, and that are kind of usually built in with a lot of our innovation. When it's something like this, a new ingredient that is now becoming deregulated, it's a little bit different. And so those things, those complexities, and I think just like the number of the acronyms right? At the federal, state, municipal level of different bodies that are evolving their approach, right? And have some form of jurisdiction over the ingredient or the product or the claims or the labeling, makes it very challenging, right? To kind of move quickly and get everybody on board and even solidify a plan, because there's usually a lot of moving parts.
Indeed. Thank you, Kathryn. And Chris, let's go to you next. From your perspective at the International Cannabis Bar Association, can you talk about hemp cultivation and production? It's currently governed by the USDA in the states, as we heard from Mai. But under the current rules, as we've mentioned also, psychoactive cannabis, THC-containing cannabis, remains federally legal, which leaves regulation on that subject matter solely to the states. Can you tell us from your perspective how you might see regulatory framework unfolding at the federal level in connection with regulatory structures at the state level? And do you see it unfolding in a way similar to the interactions between federal and state regulations in the hemp industry?
Yeah, so I mean, it's an interesting and it's a very complex question. I think that, so as Mai mentioned, right, between what we like to think of this as is a cooperative federalism model, right, where we have a federal floor and then we have state governments that are allowed to implement their own plans. They have to adhere to this floor. They can have higher regulations if they like, but it's not required. And of course, they can fall back on this federal plan if they'd like to, and they can implement that instead. As Mai mentioned, the USDA takes care of everything that is still in the ground, right, up until harvest. And so what we see with the USDA is this plan around sort of what is allowed to be cultivated, the concentrations of THC, those sort of issues. As Mai mentioned, the second half of that equation has yet to be highly regulated, right? And so this falls on the FDA. And so when we're talking about psychoactive cannabis, the largest concerns for the industry have to do with how to actually get your products in front of consumers. And so I think that when we're looking at this, and if we're going to use this hemp model, what we would possibly see in the future when we're looking at the FDA is a version of this cooperative federalism, right? And so Mai mentioned, the non-preclusive effect of federal regulations in this area. Something like that could occur with the FDA, where they come up with a certain standard, a baseline standard of health requirements for health and safety for public health. And then we have states that are looking at this and they sort of decide, well, hey, for our state, maybe a higher standard is appropriate here. And so here in California, I sit in Oakland, we have one of the strictest testing standards in the country, right? And so it's completely plausible that the FDA may come up with one of those baseline plans that is a little bit below California. Of course, then we'll look at sort of a fractionalized market as we go forward. One of the things that you mentioned in your introduction was just how many different jurisdictions there are in the United States. When you put the municipal regulation on top of county regulation, on top of state level regulation, this is a really fractionalized market. And with that type of mechanism going forward, what we could see is something that we see in other industries, right? For instance, we see it in the auto industry with car emissions, where we have different standards for auto emissions in different states. What has happened with the auto industry is that basically everybody adheres to California emissions standards because it's too difficult to have 50 different supply chains to adhere to all of these different levels of standards, even if you're allowed to sort of go to that federal floor in a different state. And so that's one of the things that could happen. We could sort of see coalition, or sort of the coalescing of regulations around a high standard, just so that, companies like UNILEVER that have large sort of single, would like to have a single set of a supply chain to be able to adhere to all 50 of those regulatory structures at the same time. So I think that that's one of the places we're going to see. Of course, our audience here are steeped in the beverage industry. So there is discussion under the Cannabis Administration and Opportunity Act, also involving the TTB. And so the Tax and Trade Bureau, obviously right now, they govern tobacco and alcohol. There is some sort of discussion of having that agency involved in the tracking of the entities that are involved in the industry in order to allow for a federal taxation structure, while still allowing the FDA to govern those sort of health and safety public aspects of it. And so as we move forward, part of me is sort of wondering, whether there is an appetite within the USDA to start governing those aspects of cannabis cultivation upon legalization that are not hemp, right? That are over that 0.3 threshold. And because that would sort of, in my mind at least, right, then you have the cultivation aspects. Anything that's in the ground is governed by USDA. Anything that you're putting in your body would be governed by the FDA. And then we're dealing with business entities and product tracking and taxation. We're dealing with the TTB. And for those first two, for the FDA and the USDA, I think that we'll likely see something like this cooperative federalism model. And a big reason for that is just because of how much money has already been deployed in the industry. And so there have been billions and billions of dollars that have been spent building these supply chains. And so if we're going to sort of wipe all that out with a single federal standard without paying attention to what the states have already implemented, I know that would upset some investors in the current industry. And so you might have a little bit of pushback there.
Chris, can you tell us about how I'm talking in regard to hemp now, regulations do vary from state to state. So as an example, if I'd like to get a product, a drink containing some aspects of the plant onto the shelves of one state, how does that differ as compared perhaps to getting that same drink onto the shelves of another state from your perspective?
Sure. And, I want to leave some of this discussion to the next panel because I know that there's a fireside chat that specifically deals with sort of the experience of certain individuals and how they've gotten those products on the shelves. If we're talking about the differences from state to state, right, we're dealing with a different set of regulations no matter where you happen to end up. And so in certain jurisdictions, they may prohibit certain adulterants, right? Anything that makes a cannabis product more addictive, anything that makes it sort of more attractive to children here in California, that's kind of a big no-no, right? And so if you're talking about either advertising or the additives on the actual cannabis products, you have a lot of restrictions there. In certain other states, they will prohibit you from, for instance, putting in a distillate from a hemp extract, right? And so hemp and cannabis, it's generally the same species of plant, right? The difference is that the hemp has less than 0.3 THC. That psychoactive cannabis has more than 0.3 THCs, but these are generally the same species. They're just bred in a little bit different ways. In many states, you can't use, for instance, the terpenes, the flavor profiles of a hemp plant in a psychoactive cannabis plant, right? So you have to be very careful. And depending on sort of where you are in your supply chain, you can have sort of mixing of state supply chains, right? And so if you're talking about packaging and labeling, although we don't have a 50-state standard, you can imagine a world in which, 15 states sort of rely on a set of packaging requirements that look sort of similar. And so you can go to, the most stringent of those requirements, and you could have a single facility in a single state that creates, 15 just slightly different sets of packaging that are compliant in each one of those 15 states. But you could do that in a single factory. When you're dealing with the actual cannabis and the cannabinoids that come out of that cannabis, you really do have to silo your supply chains because of the federal prohibition on psychoactive cannabis. So that 0.3 threshold, you can't mix those supply chains. And so while, getting your product on the shelf, from a packaging perspective, you could have sort of like one main plant that puts out a lot of the packaging. You have to set up either relationships with local cultivators or your own cultivations facilities in each one of these different jurisdictions, because right now there is no interstate commerce in cannabis.
Very good, Chris. Thank you. And on that notion of state-by-state variance, Kathryn, how does this affect, if at all, Unilever's approach to marketing hemp-containing products here in the United States, given, again, the variance that we just heard Chris speak about in the regulations of one state as compared to the regulations of another state?
I think it's one factor that's obviously really limited us, right, in terms of what we might pilot or even, experiment with, because when you add that much complexity, the cost just becomes astronomical. And on top of that, there's still, there's a lot of risk in terms of things like your supply chain, having some cross-contamination. And, if we were considering something like putting CBD in a food and refreshment product, or, if there is, if suddenly THC is legal, we were considering that, even if it's legal, that's really only like the first hurdle. It's the practicalities of trying to constantly manage. It's not like you would even be able to do a deep dive, get to your lowest common denominator and set things in place, because things are constantly evolving. And so because of that, I would say on the cosmetic side, with the hemp seed oil products, the biggest difference that you're going to see, like from a consumer's perspective, is you'll see a disclaimer, right? Making things really clear, this does not contain THC or CBD. There's probably a lot more attention to the, romance copy that's chosen for those labels, right? Because you don't want any kind of inference or implication that this product is going to do something that it shouldn't. And so I would say that's probably the biggest difference from a consumer's perspective. It's really kind of like making the sausage. That's the hard part.
Kathryn, you had mentioned, you hypothesized as in regard to THC, if it were legal. Let's talk about that for a moment. If THC were legal, if prohibition were to end in the United States, whether it's in the next few years or in 10 years, could you see UNILEVER at that very future time actually entering the U.S. cannabis market, putting cannabis THC containing products on U.S. shelves?
I certainly cannot speak for UNILEVER, right, in that sense. But what I can say as an observer is that they're generally very interested, right, in being on the front lines, but where it makes sense. In the event that there is a real sustainability advantage to moving to this product, right? If there's something that they feel is really going to make a big difference in the lives of consumers, it's going to really solve a consumer problem, then I think they would be considering it. Again, being legal is just means that you start, right, trying to rolling up your sleeves and trying to address the real challenges then. First and foremost, we're going to be really concerned about safety, and there's still a real lack of publicly available research out there.
Yeah.
Right. So that's a big part, and that's something that UNILEVER takes really seriously. If we saw the real opportunity, I'm sure we would invest, but I wouldn't think that we'd be in the market, 30 days after the announcement. I have been, I like to kind of stay on the front lines. Otherwise, you can't keep up with the marketers. And so I've been spending time on Clubhouse, which is a fairly new social media platform. Indeed. And just last night, joined a Clubhouse chat on cannabis. And this one was really actually about the benefits of using hemp as a building, like for construction, as a building material.
Yeah.
And so it did open up my eyes to the fact, I don't believe everything I hear on Clubhouse, but I do think that there is a lot of opportunity out there that we haven't really completely considered because it is not legal right now.
Great points there. And I also want to echo your point that just because legalization occurs doesn't mean that the game is over. It's really just getting started, and the mess really is just getting started at that point. And I know Chris and I have been watching that over and over again in the cannabis industry as various states unwind regulatory programs. Then the conversation really gets started on how to do it right. So it's really challenging, but it's also a lot of fun, I think. What I will point out is I think it's very exciting, just from a standpoint, a human perspective, that companies like UNILEVER actually might, and I heard you say might consider, but actually might consider that we're actually have a conversation about what UNILEVER might or might not do in relation to THC containing products. And I think just the fact that a great company like UNILEVER, that you could even say that these days, I think is just a sign of how far we've come. So I find that to be a very exciting conversation.
We do counsel Ben and Jerry's.
Yeah.
and so I would say, again, right, we will have the conversation always, keep an open mind, have the conversation, but it's really at the end of the day, it's going to come down to safety. It's going to come down to, does it align with our core values? Does it make sense? And getting all those ducks in a row.
Right. Thank you, Kathryn. Maya, I'd like to come back to you. Can you tell us about the status of the USDA's implementation of the new final rule relating to states that have been operating under the 2014 Farm Bill pilots? You're on mute, Maya.
Thank you. Sure. So before 2018 Farm Bill, there was a 2014 Farm Bill, which allowed states to have a pilot to basically test the cultivation of hemp. And that pilot didn't have much requirements or regulation. They had the definition, but there was no testing requirements, and it certainly the states were able to experiment. And USDA, and frankly, very few agencies had direct regulatory oversight over the state pilots. And the way the 2018 Farm Bill was written was that pilot was to sunset a year after USDA issued its regulation. However, that sunset date has been extended a couple of times in appropriations bill, and so it hasn't sunset yet. The latest sunset is actually the end of this year. We haven't gotten any word whether or not there would be an extension. So that said, the reason why I bring that up is because there's about 8 states right now that operate under the 2014 pilot. And of those 8 states, 2 of them also have a USDA plan that they have sort of put in abeyance. So it's sitting out there as approved, but they're not actually operating under that. And then an additional 26 more states have USDA plans, and they're in varying degree of implementation. And then we also have 3 states that are using USDA plans. So they said, we're not interested in regulating. If our growers, if you want to grow hemp within the state, go apply for the USDA plan. And then on top of that, we have dozens of plans that have been approved for tribes. And tribes have jurisdiction over hemp cultivation within their territories. So in fact, like in a state that has a number of tribes like Oklahoma or California, the jurisdiction is actually split among the U.S. government, the state government, and then the tribal government. And so that's another wrinkle in how it's being regulated. And so we're waiting to see whether or not the 2014 pilot will continue. If it does, and then it usually is given another year in which states are operating on the 14 pilot, so they're not subject to the testing requirements, they're not subject to the remediation requirements that are in the 18 Farm Bill and the 18 Farm Bill regulations. And that has given us, so it's hard for us to really completely predict how that transition's going because, as you can imagine, among those 8 states, that are under the Farm Bill 2014 pilot are the big producing states. So Oregon, California, Colorado, Kentucky, they are all operating under their 14 pilot.
Can you give us some insight, Mai, as to the major changes between the interim bill and the final bill, the final rule?
Yeah, so some of the major changes is really to really help the farmer for predictability about their product. About the crop. And so some of the things that we have done is codify a enforcement discretion that was implemented back in the spring of 2020, which allowed, if you had a hot crop, it allowed for remediation versus saying you absolutely have to get it destroyed by a reverse distributor that has to be restored with DEA. So remediation allows them to plow it under, allows them to destroy it on farm, to mix it up with other things to make biomass that test below the point, below 0.3. And so there's a little flexibilities there. The other thing that we did was we allowed the state plans to have more flexibility in terms of sampling. We had a really strict sampling, not strict, but we had a very prescriptive sampling requirement. And we recognized the comment that some of the states wanted to provide a little more flexibility in sampling, especially in the areas of research, but also in the areas of risk base. And so we said to the states, if you can have a sampling regime that meets the standard for us is 95% degree confidence, then you can implement your own plan. And so like states that may have like a certified seed program can now use that as part of the risk-based approach to sampling. The other thing that we did was in terms of the negligence violation. So in the IFR, we set like as a threshold at 0.5 THC level before we consider a violation to be negligent. That got raised to 1%. And so again, it was basically having had a year of cultivation under our belt, we realized that there were areas where we can provide some flexibility. So that's some of the areas where we did and end up providing that flexibility.
Very good, Mai. Thank you. And it's great to have that federal perspective here on the panel. Chris, let's talk about IP and brands in this space. It's a little weird, right? Because on the one hand, you have the federal government saying this stuff is illegal, commerce relating to THC-containing products are illegal. And also you have the FDA, which says that certain products, even those that don't contain THC, can run afoul of our own regulations. For instance, when you're dealing with CBD in foods and so on and so forth. So there's a great deal of interaction between the government agencies. And that, of course, affects the PTO, the Patent and Trademarks Office perspective on granting trademark registrations. It makes IP rights a mess. The lawyers are happy because lawyers like messes, but I don't think anybody else is happy about that. So can you tell us a bit about how that plays out and what you've seen happen in the space in that regard?
Yeah, and I have to admit that I don't even think the lawyers are happy about this one.
That's true.
But just a couple of notes, Kathryn. If you ever need help figuring out how to tackle a different jurisdiction, I have 800 very good friends that would love to help you. So if you ever need to reach out, for anyone that's on the line, people like Tom, make up our ranks, and we all learn from each other. And that's one of the benefits of having an association like that, is that we get to cover all of these jurisdictions. And for a place like California, the counties and the municipalities matter as much as the states in terms of licensing and compliance. So please do reach out if you have those issues. And those points that you made about testing hot, so testing over that 0.3 and removing that regulatory cliff, right? So once you test hot, not actually running into a criminal violation, that was so important for us. And the remediation prevented total loss for crops, which was, again, incredibly important for the industry. So we appreciate all those things. In terms of IP, Tom, you're right. It's at the USPTO. Obviously, there's a few different types of IP protection. We have patents and we have trademarks. I'm going to start with trademarks because that's sort of the problem that we're running into right now. There is something called the lawful use requirement, which requires that trademarks be used in actual commerce to be protectable, right? And so you can't have an idle trademark, one that just stands out there that you have trademark rights to, but that you never make any money off of. One of the requirements the USPTO actually implements is sort of, they look through it and they make sure that, hey, there is going to be a market for this on the back end. So what they've done for THC is they've looked at the CSA, the Controlled Substances Act, and they've decided, well, psychoactive cannabis is impermissible under the CSA. So we're not going to grant trademark protections for this industry because there's no possible market that would be legal to unload these products in. Similarly, Mai mentioned that CBD was the basis for a epilepsy medication called Epidiolex. Since CBD is in Epidiolex, and that's that active ingredient, under the Food, Drug, and Cosmetics Act, the drug preclusion rule means that, as Mai mentioned, you can't use that in a different substance without FDA approval first. When the USPTO applies the lawful use requirements, either to the psychoactive cannabis market, looking at the Controlled Substances Act, or at the drug preclusion rule, looking at CBD products, they make getting a trademark for cannabis products impermissible. This means that there's no brand protection if you are in the CBD or the psychoactive cannabis market. You can get trademarks if you get trademarks that are sort of aimed at different areas. Of course, there's a question of enforceability once you do start using those in the industry. It's a little bit funny because the FDA itself, which is in charge of enforcing the Food, Drug, and Cosmetics Act, again, as Mai mentioned, CBD is impermissible to sell over the counter because of that drug preclusion rule. The fact of the matter is that the FDA has not widely enforced that rule. And so you will see CBD products around. Most of those don't have trademarks. They have very poor labeling. Sorry if there's any CBD drink companies on here. You should improve your labeling. But that's sort of the way to tell that that's a product that hasn't been examined by the FDA. It certainly hasn't gotten one of those approvals. You know, Kathryn had mentioned that there were some, you know, issues around labeling and exactly what to do with, you know, hemp extracts versus CBD and exactly what to say about it. The one thing that the FDA really does crack down on are statements towards therapeutic uses for CBD or hemp products, right? And so you can't say, this will cure your headache or this will cure your cancer. You can say things like, this may help with something, or actually, I don't even know if you can say that. So erase that from your mind. But individuals that operate in sort of that nutraceutical sphere, you know, they're very well versed in sort of the structure function claims and different areas that you need to be very, very careful of with the FDA. And of course, those issues flow through to the USPTO and sort of prohibit any trademark IP protections. Although if you talk to a good trademark lawyer, they could potentially help you there. On the patent side, we don't have a lawful use requirement. And so actually one of the first holders of a patent for medical use of cannabis was the US government, despite the fact that it remains on Schedule 1. So I don't know, that math doesn't add up to me, but that's what we got.
Thank you, Chris. That was very helpful. And I do have some follow-up questions. But first, I've been asked to repeat the CLE code, so I'm going to go ahead and do that. The CLE code, for those of you who are looking for CLE credit, is G as in Gary, U as in U-boat, 1256. That's G as in Gary, U as in U-boat, 1256. So Chris and also Kathryn, maybe you have some insight here. How does that play out in terms of developing a strategy to protect brands, right? So what I'm getting at here is ultimately it's all about branding, right? Or at least certainly a large portion of the conversation we're having, this conversation relating to cannabis and CBD and hemp related commerce, it's all most of it's about branding. So how can you have that? How are folks having that conversation now? How are people protecting brands in terms of overall strategy, given that the PTO is giving companies such a hard time on issuing related federal registrations? What have you seen play out?
And Kathryn, please feel free to jump in at any point here. I have to admit, I'm not a trademark attorney. I have many friends that are, and they have very comprehensive brand strategies. One of the problems that they see with clients that walk into their office is that they go to a traditional trademark attorney that is unfamiliar with the cannabis industry. I had a conversation yesterday with one of our trademark experts. They had a client who spent an extra $8,000 because they applied to a sort of the entire gamut of protections for their particular mark. There's really only one that can offer you protection, one or two in there that could have offered this particular client protection. And so had they talked to somebody that was familiar with the trademark landscape, they would have been able to get that protection for a lot less and saved a lot of money. So that's my advice. Find someone who is steeped in trademark law in the cannabis industry. If you're filing a patent, do the same thing. You know, Dr. J on your team, Tom, I have a tremendous amount of respect for her. So talk to someone like that if you're really interested in having some IP protection in the industry.
That's great. Kathryn, anything to add on that? And I do have something to add myself, but first I wanted to give Kathryn, if you have any insight there from
sure.
Actual very large brands. Yeah.
You know, I would say we haven't had, most of what we've done is under an existing brand, right? Mm-hmm. So you're talking about this being a featured ingredient that they're focusing on. But if we can't then get a registered trademark for the variant name of that SKU, we haven't had the same challenges yet, right? I think where the intellectual property challenges are really coming from are the ones that are like our suppliers might be having, right? Trying to really own a particular type of extract or a version of this, right, is really hard. Or if you're launching a product in the cannabis territory, I definitely read some interesting cases that are actually kind of, entertaining in the intellectual property space. Everything from like celebrities suing because they're being named after products, or right. For us, in terms of protecting the brand,
yeah.
We haven't been spending lots of time talking about like THC, but in the CBD space, it's more than just, okay, well, this is what we would have to do to produce a product with CBD in it. It's also about, have you taken a look around? Do you, how will this impact your brand and what it stands for already? So for instance, if you are PETA certified, your certification may not allow you to use CBD in your products because it's being tested on animals right now.
Right.
And so there's all of these other considerations related to more almost like the reputational risk of going down this path, that I think are healthy and good to have in an open discussion with the brand. That it's not like you're coming down on them and saying, this is why you shouldn't do this. It's more, have you considered this? Is this something that you're comfortable with, right, taking on, or maybe is this more complicated than you thought?
Indeed. Kathryn, thank you for that valuable perspective. And I will add, because I happen to be an IP attorney, as Chris mentioned. And really what it comes down to, Chris is right, you really do need to find attorneys that are experienced both in IP law and are familiar with cannabis issues. And cannabis regulatory issues at that. But as a general notion, really it's a specific conversation that changes based on the company and the brands and the products that they're launching. And it's always a very custom built solution that you ultimately come up with. So really what it comes down to is asking where you want your company's brands to be in 5 years and 10 years, and then working backwards to have the best path toward that possible future IP ownership outcome. And that typically will include a soup, if you will, of various types of protection. You'll want to protect yourself at the state level in each state in which you're currently doing business, because ultimately, if you're enforcing your brand in the short term during the you're going to consider very carefully whether or not you want to bring that case in state court, because you may get more cooperation, obviously, from a state court judge than you do from a federal judge, given federal prohibition. At the same time, the long-term valuation of your brand can be supplemented or even primarily contributed to by federal trademark protection. And so there are ways to get creative because there are legal things that your company may be putting into commerce, and you can leverage those to create brand protection that may, through theories like the zone of expansion and other IP theories, actually spread out beyond the particular narrow scope of your trademark descriptions. So that gets into some, I guess you could say, some legal jargon. So I won't go too far into that. But Chris's note that you really want to find an attorney that understands IP law and understands the cannabis regulations as relates to to trademark law, and in particular understands the FDA's also their perspective and how they put their hands into the PTO's business when it comes to cannabis-related products seeking trademark registration from the federal government. That really makes a whole lot of sense. So, Chris, thank you for that. And Kathryn, thank you very much for your insight. I do believe that we're out of time here, so I'm going to close. Chris, did you want to say something else?
I just wanted to mention that there is one case on this IP issue. It's Inri Joytea, Joytea. It's an iced tea company. The notice of appeal went up, I think, a week and a half ago. So anyway, if you guys are curious, it's a good place to start with federal protections. As Tom said, you need the gamut. You need state protection.
Thank you, Chris, very much. And I want to thank my wonderful panelists. That was a great presentation. And really, I personally enjoyed hearing such varied perspectives here. I thought that was really a great variance, a diversity of perspective here. So Dinh from the USDA, thank you very much. Kathryn Farrara over at UNILEVER, thank you very much. And Chris Davis, it's always great to see you from INCPA. Thank you very much, all of you, for your great contributions. And thank you, everyone, for listening. Greatly appreciated your time today.
Thank you. Bye-bye.